Your Honors, you ready?
Yes. Yes.
May it please the court. I am Assistant Appellate Defender Andrew Desimoni, and I represent Mr. Hewitt. And I'd like to reserve 5 minutes for rebuttal. The correct Batson analysis, which requires looking at all of the circumstances and doing a full comparative juror analysis, has been settled law from the United States Supreme Court since Miller in 2005, and from the North Carolina Supreme Court since Waring in 2010. Hobbs did not say anything new, but still no court has ever fully and fairly ruled on Mr. Hewitt's Batson claim. The trial court did not at trial. This court did not on appeal. The North Carolina Supreme Court did not in response to our PDR. And now the state wants this court to kick the can further down the road. But enough is enough. It's been 5 years since Mr. Hewitt's trial. The state's discrimination against Black juror Corey M. is clear. It's past time for a court to fully and fairly rule on Mr. Hewitt's Batson claim and grant him a new trial.
Well, you've made a compelling argument here about why this court should do the analysis itself. However, I'm looking at State v. Hobbs, which is what this came back on, and on page 16 of Hobbs, and in Hobbs they found that the trial court failed to do the analysis on arguments, some of the arguments almost the same as this, I believe, one of those about statistics. And what the Supreme Court said, and Justice Earle's opinion is on page 16 of the slip, is accordingly, we must remand to the trial court for a Batson hearing. Why isn't that the test, that it goes back to the trial court for a Batson hearing? And I believe I'll stop there and let you answer that question, and then I may have one more.
Sure. Part of it has to do with what happened in Hobbs. So remand for a new Batson hearing in Hobbs was appropriate because the trial court in that case could not have fairly ruled on Batson step 3 when it had found no prima facie case at step 1. And then the Court of Appeals never even ruled on step 3 as to 2 of the jurors. But that's not the case here, right? We had the trial court found a prima facie case and then fully ruled on step 3. It's a cursory ruling, but it was a wholesale rejection, right? The trial court actually got fairly close to considering the claim. It said it considered Mr. Hewitt's comparative juror analysis. It said it considered all of the circumstances Mr. Hewitt said demonstrated discrimination. It just disagreed with it all, right? It said, I don't find discrimination. I disagree with all of your arguments. That should be enough for this court to review, right? To do its own de novo comparative juror analysis. Do you agree with me, or do you agree with the trial court? That's the question that should be there on appeal. You know, and that's in line with United States Supreme Court precedent, which is binding. It's what the Supreme Court has done time and time again. Look at footnotes 1 and 2 in Miller from 2005. The trial court had not made any findings about the comparative juror analysis. As the United States Supreme Court said, it had to develop the comparative juror analysis itself. The trial court did not compile the statistics used by the Supreme Court. The Supreme Court did that itself. Yet the Supreme Court did not remand for a new Batson hearing. It reversed the conviction. Look at Snyder versus Louisiana. The entirety of the trial court's ruling was, quote, all right, I'm going to allow the challenge. I'm going to allow the challenge, end quote. That's it. The trial court did not make a finding about the juror's demeanor when the state said he appeared nervous. The trial court did not do any comparative juror analysis. That was done by the Supreme Court. But again, the Supreme Court did not remand. It reversed the conviction. Flowers and Foster, the Supreme Court did not remand for new Batson hearings. The Supreme Court reversed the convictions. And that is what this court should do. But it's not just because of binding Supreme Court precedent. It also makes sense. It has been 5 years since jury selection in this case. The trial judge is not going to remember this jury selection. The trial judge will be doing this on a cold record, even though he was there. The trial judge will have to read the transcript and the record just like this court would. We're at Batson step 3, so the state cannot give new excuses at this point. All that is required now is a review of whether the state's current excuses were pretext for discrimination based upon the existing record. So the trial judge would be in the exact same position as this court.
But and I appreciate the argument and the illustrations of U.S. Supreme Court opinions, but we are still bound by our own state Supreme Court, and in particular here in this context, Hobbs. You know, Hobbs was a 2020 case reviewing a judgments entered in 2014. So you know there you have the same time lag, which you know is sort of an unfortunate product, I guess, of the appellate process. That you do have these issues kind of sitting around, you know, for years before they're fully reviewed through the appellate process. So how is the mandate from Hobbs any different than the mandate we should apply here? You have the same time issues. It's you know, same sort of lack of fulsome ruling on the Batson issue, and a pretty clear mandate in Hobbs that even though the Court of Appeals and the trial court failed to conduct the proper analysis, the remedy is send it back to the trial court. I mean, I you know, we're the intermediate appellate court here, I think. So I think the concern is, you know, we need to stay in our lane here.
Well, another thing you can look at it, and Judge Arrowood and Judge Hampson, you're very familiar with this, is the Campbell case. You know, the majority in that case said we can rule on this record. They didn't remand it. The dissent would have remanded it, right? But that's a case on reconsideration after Hobbs in which the court did not remand back to the trial court. So it's not all of them have even gone that way. It's a mixed bag, and it depends on the particular case. And in this particular case,
that case too was also limited solely to the prima facie
right
issue, right? So
right.
Mr. Destimone, given that there are issues in addition to the comparative juror analysis, so you know, even if we agreed with you that we could rule on comparative juror analysis and deal with that here at the Court of Appeals, don't we have this outstanding demeanor and credibility issue that we cannot determine at all on a cold record? How are we ever supposed to determine that on a cold record?
Well, no one's ever going to be able to determine that, right? The trial judge, those findings are gone. It's impossible now after 5 years, just as they are impossible in Snyder versus Louisiana after 10 years. 5 years, 10 years, I'm sorry. Nobody's going to remember the demeanor of this jury, and they just won't be able to. So those excuses cannot be credited by anyone.
Well, and do you have any case law that suggests that we can't do that under
Snyder versus Louisiana?
But that's a longer time period than what we're looking at here. I think it goes back to, I think what my colleagues were saying. In Hobbs, we're not looking at much of a different time period than we have here. Is there something else that we could hang our hat on to say you can't consider demeanor or credibility anymore after this long?
I think Snyder is the best than any of us have. And I just fail to see much of a difference between a 5-year delay and a 10-year delay. They're both extremely long delays, and it just precludes any sort of credible finding of credibility after that length of time.
Well, under your theory, though, most of these cases take a substantial time to work their way through the appellate process. The Court of Appeals, the Supreme Court, and those kinds of things. Under your theory, that then in none of these cases could there ever go back and be an analysis of that. Is that correct?
No, Judge Murphy was asking me about the particular issue about demeanor. And, you know, a finding, did this person actually hesitate, or did they actually blink their eyes or whatever it was. That's all I'm talking about. That becomes impossible after a passage of time. The other things that you can review.
So under your theory, though, there's going to be a passage of time before it works its way through. Under your theory, that could never be considered again.
I think maybe it's possible after a year or two, maybe 3, but not after 5, 6, 10 years. It's just not. The trial court's also not as well equipped as this court to do the necessary review, right? The trial judge is one person with no clerks and a backlog of trial cases as the courts open back up. Now, I know how hard this court works from my 3 years clerking for Linda McGee and my 12 years practicing before this court. But at least this court has 3 judges to decide this case, each of whom have clerks. And the type of analysis needed here is this court's bread and butter, a deep dive on the transcript and the record. But really the most important reason not to order a new Batson hearing now is that based on
and I understand your argument perfectly, but I'd go back to the fact that that same argument could have been made in Hobbs, and the Supreme Court could have done the same analysis, and they chose not to. They said, and it's not that we are going to, it's that we must. And there must be some reason, because as you read this opinion along, you perhaps think that they're going to reach some other result until you get here. And then they say, we must, because they've done this substantial discussion of the facts. And then they say, but we must send it back. So I'm trying to understand, if they must send it back, then, and it's not that we're going to send it back to the Court of Appeals for them to do this analysis. It's, we must send it back.
right, but interestingly, the Supreme Court could have remanded this case back to the trial court, right? Just as easily, but they didn't. They remanded it back to this court. And I think it goes back to the difference in Hobbs is that the trial court never actually ruled on step 3 through the appropriate lens, right? You can't rule on step 3 appropriately if you have ruled that there's no prima facie case. It's like when you do a 403 analysis. You can't do a proper 403 analysis if you found that the evidence was irrelevant, right? It skews the later 403 analysis. It's the same sort of analogy here. So that was different. There are other parts of Hobbs where they say explicitly, we're not saying anything new. They said it, quote, indeed, there is nothing new about requiring a court to consider all of the evidence before it when determining whether to sustain or overrule a Batson challenge. But the most important reason not to order a new Batson hearing now is that based on the record we have, right? We have the existing full record, thousands of pages of transcript, all the jury questionnaires. The state's discrimination is clear. So this court can say that any determination by the trial court that other than a new trial would be clear error. So I do want to turn to the merits because I think it impacts the determination of what this court should do. We all need to recognize that there is not going to be a smoking gun in most of these cases in this day and age.
Before you turn there, I want to just ask one more thing. When this goes, if this were to go back down to the trial court, is the trial court doing a reconstructed hearing, or are they hearing from the state and the defendant again on these issues? And the reason I ask is the trial court just judging credibility based on 5 years of memory, or credibility at a new hearing when this goes back down? So
the only credibility would be as to the demeanor-based reason. Can the judge remember whatever the demeanor was? Okay, but other than that, it's based on the cold record, based on the transcript and the questionnaires, because we're at step 3. The state cannot give new excuses at this point. They are stuck with what they said. And so the judge is going to be doing just what this court would do, going through each of one of our arguments and saying, does this one hold up? Does that one hold up? That's all. Same review as this court. But the point is that there's not going to be a smoking gun in this day and age as to discrimination. discriminatory intent has to be inferred. But that's what we ask juries to do all the time. You know, you all must know the pattern jury instruction on intent by heart. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. Okay, jurors use that instruction day in and day out to find intent beyond a reasonable doubt. This court should do the same thing. So I want to look at some of the circumstances, starting with some of the comparative juror analysis. Because like black juror Corey M., white jurors Shirley S. and Thomas L. were also single, but the state accepted them. Like black juror Corey M., white jurors Shirley S. and Thomas L. also had not previously formed an opinion on the death penalty, but the state accepted them. Like black juror Corey M., white jurors Harold L. and Donna R. did not answer the death penalty questions on the questionnaire, but the state accepted them. Now, the state also said black juror Corey M. was hesitant about the death penalty. That's the only demeanor type thing that we've got here, but he was not. Okay, there may be a situation somehow the judge could remember this after 5 years, but I urge you to read his full voir dire. Second, even if he was hesitant, white juror Shirley S. was clearly hesitant about the death penalty, but the state accepted her. Thomas L., white juror, also hesitated when first asked about the death penalty. That's page 238, but the state accepted him. The state even accepted 2 white jurors, Donna R. and Shelley S., who used to be completely opposed to the death penalty. Now, the state also said it struck black juror Corey M. because he said he hoped the prosecution got the right person. He said there had been some instances where the wrong person was put in prison. But white juror Matthew P. said he had mixed feelings about the death penalty because it had been used to kill innocent people, yet the state accepted him. The state also asked different questions of white and black jurors. Now, when black juror Corey M. said he had not previously formed an opinion on the death penalty, the state asked 3 follow-up questions about his opinion on the death penalty now, after sitting through jury selection. But when white juror Gary T. said he had not previously formed any opinion, the state did not ask him any questions about his opinion on the death penalty now. The state just asked him yes or no questions about whether he could follow the death penalty process. That is a classic prosecution technique when they want to keep a juror. That is pages 867 to 875. As the Supreme Court ruled in Flowers, quote, prosecutors can decline to seek what they do not want to find about white jurors. Also, the intense questioning of Corey M., which was different than the white juror, produced his responses that he hoped the state got the right person, which the state then used as an excuse to strike him. As the Supreme Court also said in Flowers, quote, disparate questioning and investigation of prospective jurors can, on the basis of race, can arm a prosecutor with seemingly race-neutral reasons to strike the particular prospective jurors of a particular race. The state also asked Corey M. about his failure to answer the death penalty questions, but didn't ask white jurors Harold L. or Donna R. about their failure to answer the same death penalty questions. The state also did not ask questions about issues it later said it was concerned about. So, for example, the state never asked Corey M. about his statement to the court that he could serve even though he wouldn't get paid through his employer. The state never even asked Thomas L. whether his employer paid for jury service, and never asked him about the financial impact on him of a 3-month trial. Statistics. The statistics also showed the state discriminated. At the time the state struck black juror Corey M., the state had stricken 75% of qualified black jurors, but only 23% of qualified white jurors, and was therefore 3.3 times more likely to strike a qualified black juror than a qualified white juror. That's an even bigger disparity than was found in the Racial Justice Act study. This case was also particularly susceptible to racial discrimination in jury selection. Mr. Hewitt was a black man accused of murdering 3 white people in rural North Carolina. Now, George Floyd, Breonna Taylor, Ahmaud Arbery, all the events of last year, the events of this year show us race still matters in this country and racial discrimination is still alive and well. The state's comments at trial also gave rise to an inference of discrimination. I mean, the state put out a press release with the racial composition of the jury. That showed race was important in the minds of the prosecutors.
Mr. Destimon, let me ask you about that aspect of your argument. Since that is something that occurred after the trial court's ruling on Batson challenge, was there any mechanism or request to reopen jury selection, to reopen and readdress the Batson challenge? Yeah, I'm trying to figure out how that comes into play at all for the trial court's consideration. If we're reviewing if the trial court erred, how something after the decision and after the court's order can ever be factored into that.
Right. 2 things there. One, the defense counsel did bring it up. They actually filed a motion about it, a separate motion dealing with the press release. But the defense counsel made the argument to the judge. That shows race was important in the minds of the prosecutor. That's exactly what the defense counsel said. Now, the comparisons I drew in my briefs were to jurors that were questioned before Corey M. to avoid this. But the United States Supreme Court precedent requires us to look at everything, right? It doesn't matter when. So for example, the United States Supreme Court also often looks at statistics of jury selection as a whole. A lot of those statistics are coming from jurors after the strikes in question. It doesn't matter to the United States Supreme Court because we're looking at everything to determine the intent. Okay, so yeah, maybe it's not fair because the trial judge didn't know that till later, but this court has that in front of it. The state also adopted the trial court's inappropriate racial stereotype that Black jurors might be leaning towards life while white jurors might be leaning towards death. That again showed race was important in the minds of the prosecutors. Just listen to what the trial court said, which prompted the state to note that the alternate was white. The judge said, quote, "You know, the thing that you might be doing is getting rid of a juror who is very much at this point leaning towards life and replacing her with a juror who is very much leaning towards the opposite potential punishment in this case. You're asking me to excuse one of the only 2 African-American jurors in this group. Your client is an African-American. There's a lot to be said for keeping an African-American on the jury." That's what the judge said. The state also gave pretextual reasons for striking another Black juror at the same time as Corey M. Okay, the state struck Black juror Charlene S. And the first reason they gave was she was unemployed. But they accepted white jurors Mary W. and Harold L., who were also unemployed. The state struck Black juror Charlene S. because she knew 2 defense attorneys, but accepted 3 white jurors who knew the same defense attorneys and had even retained them. The state also struck Black juror Charlene S. because she'd been convicted of writing a worthless check, which the state said was a crime of dishonesty. But the state accepted white juror Thomas L., who lied about his convictions on his questionnaire, and then also had an unserved indictment for felony embezzlement, a very serious crime of dishonesty. So I did want to talk about some of the merits because they do drive home the point. This is basically going to be a cold record review. This court is in as good or better position than the trial court to do it. I'm happy to answer any other questions right now, but otherwise I will reserve the remainder of my time.
Mr. Destimon, just as to the merits a little bit, if you can remind me, what was the strike rate of the Black jurors and the strike rate of the Black male jurors?
So at the time they struck Corey M, it was 75%. I have a chart at the principal brief, the original brief, appendix page 1. And so the state struck Corey M, a Black male, Charlene S, a Black female, Francis B, a black female, and they accepted Sherry J, a black female.
And no black males were actually on the jury, correct? At the end, it was only
Correct.
black females. So all 100% of black males were struck.
Yes.
Thank you. Anyone else have any questions at this point? Okay.
Reserved.
Mr. Sanders? Thank you, Mr. Drisman. Mr. Sanders, we'll hear from the state.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Nick Sanders, and I'm an Assistant Attorney General with the North Carolina Department of Justice, and I'll be representing the state in this matter. I'd like to briefly begin by defining the issue that is before this court on remand. This court has issued an opinion, and it has determined that the trial court did not commit clear error when it denied defendant's Batson challenge to juror Corey M. After this court issued its opinion, and while the defendant's PDR was pending, the Supreme Court issued its decision in State versus Hobbs. The Supreme Court then allowed defendant's PDR and remanded to this court for an explicit and a limited purpose, and that is solely for this court to reconsider its decision in light of Hobbs. So with that, I think it's necessary to look at the Hobbs decision to see how it affects this case. And I know, Judge Arrowood, with your questions, you've already kind of touched on what Hobbs requires, but I'd like to take a deeper look at that. And
Mr.
Hobbs,
Sanders, before we go there, I'm just looking at what's before us on remand. Isn't part of the problem or the suggestion, at least by defense counsel, that we only really looked at one factor and didn't see clear error there, and therefore we didn't do a totality of the circumstances analysis, and that would open everything back up?
I don't believe it would open everything back up, Your Honor. What it does is it requires this court to reconsider its decision and how it analyzed the trial court's ruling under the clear error standard in light of Hobbs. So the question is just how Hobbs affects this court's opinion, whether that's an error that the trial court committed or this court committed. What's limited is the four corners of Hobbs and what that holds and how it impacts this case. And if you look to that decision, the Supreme Court found 3 legal errors in the trial court's Batson analysis. And the only error that is relevant to this case is the trial court's failure to explain how it conducted a comparative juror analysis. So in that case, the defendant argued that the state's reasons for striking the challenged jurors was pretextual, and the defendant supported that argument with a comparison between stricken black jurors and white jurors whom the state passed. The trial court, when ruling on that Batson challenge, addressed disparate questions argument, and it also stated that it, quote, further considered the defendant's arguments about the compared responses. The trial court did not make any findings of fact explaining that further consideration. And subsequently, on appeal, this court similarly did not discuss the comparative juror analysis. Now, the Supreme Court held that this was error. It said that it did not know from the trial court's ruling, from its statement that it just further considered the defendant's arguments about compared jurors, that it didn't know how or whether the trial court conducted these comparisons between the jurors. So that was the error in Hobbs. The next issue was the remedy that we've already touched on here. In accordance with the longstanding roles of appellate and trial courts, the Supreme Court held that the proper remedy in that circumstance is to remand to the trial court for reconsideration of the issue. Specifically, it remanded for a new Batson hearing and for the trial court to make the appropriate findings of fact and conclusions of law. And this isn't just Hobbs that found this error and fashioned this remedy or employed this remedy, so to speak. This court has a published opinion in State versus Alexander, which interpreted State versus Hobbs, and it found the same error. If you look to Alexander, the defendant compared the stricken black juror to a white juror whom the state passed. The trial court said that it considered all arguments, but did not explain its consideration of the juror comparison argument. And defendant, I believe, is trying to distinguish Hobbs on the fact that Hobbs, the trial court in Hobbs did not reach all 3 steps, but I believe it did reach the step on one of the jurors. And in any event, that ignores Alexander, where the trial court had a full Batson hearing, reached all 3 steps, and found no impermissible strike. But still, it committed to
Alexander is unpublished, correct?
It is published, Your Honor. And so in that case, the trial court proceeded to all three steps, and it found no impermissible strike. But still, this court, when reviewing that, said that the trial court statement of repeating the defendant's argument about a comparative juror analysis, that's not enough to allow this court to review how the trial court actually conducted the comparison and evaluated that evidence that was presented to it at the third step of Batson. And this court in Alexander did not employ a different remedy than in Hobbs. In fact, it found itself bound by Hobbs and remanded the matter to the trial court for further specific findings because it was, quote, unable to discern from the record how or whether the trial court considered defendant's comparative juror argument.
Do you agree that whichever court it is that ends up conducting this review, the correct review, that it's broader than just checking the box on a comparative juror analysis? Is it not sort of more of a totality of the circumstances type test where a reviewing court is required to look at the whole record, not just comparative analysis, to determine whether the three prongs of three aspects of Batson are met?
So if I'm understanding your question correctly, the goal of the appellate court, and I believe Flowers touches on this.
Any court reviewing a Batson challenge, they don't just take one. It's not just looking at comparative analysis, right? It's looking at a more holistic view of the record to discern whether there was in fact discriminatory motives in not selecting.
Correct. What the appellate court.
So in this context, if it's remanded for a Batson hearing, it's not just checking the box on a comparative juror analysis. It would require the court looking at this to review the whole record and make its own determination as to Batson all over again.
I think what Hobbs would require the trial court to do on remand is to explain how it considered. So we know from the trial court's ruling in this case that it did consider the argument regarding the comparison between the jurors. What Hobbs requires, though, is for the trial court to explain how it did it. So on remand,
if they have to do the comparison on the statistical analysis, in order to make a true determination as to whether or not the state's intent was discriminatory, they have to look at the whole record and revisit all of these other items. They can't just put it in a box and look at this one thing. They've got to review the entire record. Do they not? You would concede that, don't you?
So on remand, the trial court does have to make further findings, and it has to make accompanying conclusions of law on why it's deciding how it is on the Batson determination. I don't believe the trial court has to open up and redetermine its findings that are honestly completely fine in this case. What Hobbs is taking issue with is this comparative juror analysis, because you have an argument that's been presented to the trial court. The trial court considered it, but didn't explain how it considered it. So what Hobbs is requiring is on remand the trial court to make that determination, and then from that determination, it would ultimately make the necessary conclusions of law about whether the state intended to discriminate at the third step of Batson. So in some ways, what Hobbs isn't requiring in this case is a full, complete reconsideration of everything that has been done. It's simply requiring the trial court to, for lack of a better term, explain its work and show how it had evaluated the evidence that the parties presented to it. If I'm understanding.
But how can it do that without doing a full determination of the record?
It would reconsider the factors that it's already considered, Your Honor, but that doesn't mean that the other factors and circumstances that have gone into this are completely blown wide open and everything has to be started anew. The trial court just has to explain how it's considered. So that's what's happening on remand. That's what Hobbs and this court's cases following Hobbs would require of the trial court on remand.
Mr. Sanders, is there anything different in the analysis that we could do versus the trial court, with the exception of the demeanor of the juror? What factually would put the trial court in a better position other than the demeanor of the juror than our court?
Sure, it would be the fact that the trial court heard the evidence in the first place. It viewed all, for example, with the comparative juror analysis, it has viewed all of these jurors who have come in, including Corey M. and the jurors that the defendant is attempting to compare Corey M. to. So the trial court has that benefit. And this court, our Supreme Court, and the courts have described that the trial court is the one who initially enforces Batson. So it should get again, I apologize for using colloquial terms, but it should get the first crack at making these findings of fact and making these comparisons. And you have language from the Supreme Court, and I believe it is in Snyder, that warns of that a comparison of jurors based on a cold appellate record may be very misleading when alleged similarities were not raised at trial. In that situation, the appellate court must be mindful that an exploration of the alleged similarities at the time of trial might have shown that the jurors in question were not really comparable. So the benefit is that the trial court has heard all of this evidence in the first instance. This court, and I understand that the trial court would likely use the appellate record in reconstructing and making its further findings of fact, but this court is in a different position than the trial court because this court has not yet heard, it did not personally observe these Corey M's voir dire and these other jurors' voir dire as the trial court did. And I understand.
How do you respond to defendant's argument that it's been 5 years and the trial court is in no better position to remember that than we are from the cold record?
I would take exception to that, Your Honor, because as with the case, I believe Judge Hampson might have mentioned, that's the appellate process. Cases take a long time in appeals, but that has never prevented this court, and it certainly didn't in Hobbs. In Hobbs, you have almost exactly the same time frame, I believe. You have a little over 5 years between when jury selection took place and the Supreme Court's decision remanding for a new hearing. That was a little over 5 years. That's what we have in this case. It's the same time period. In Hobbs, if you look, the Supreme Court had full recordation. It had a transcript of voir dire. So there are no circumstances that are different in this case than in Hobbs. But Hobbs made the determination, likely in accordance with our longstanding roles of appellate courts and trial courts, that the trial court is the one who should be making these determinations and should be explaining how it viewed these juror comparisons. And then subsequently, the role of the appellate courts is to review that determination for clear error. The Court of Appeals, despite having a full record before it, and despite time passing, doesn't get to become a fact-finding body just because the appellate process takes a long time. That has never been the rule in the state. And Hobbs, I think, clarifies that pretty clearly. I mean, again, if you look at the facts, 5 years, full recordation, it's not any different from this case. So the defendant on that point hasn't distinguished Hobbs in any meaningful way to show why the trial court, in this case, can't make findings like the Supreme Court held it could in Hobbs.
Mr. Sanders, I want to share with you, I'm going to share screen, State versus Sides 376 NC 449 that was decided by our Supreme Court after the close of briefing in this case, and share this highlighted language with you. 1 second. Hopefully this works. Are you able to see the highlighted language here?
I can, Your Honor. It's just a little small.
Okay, let me try to. Is that making it any better at all?
That's perfect.
Okay, and then I'll scroll up to the other section. If let me know when you're done with this. And this was from December of 2020 from our Supreme Court in State versus Sides. And
okay,
this was
just the blue highlighted portion.
Yes, sir.
And whenever Your Honor and others are ready, I'm ready to scroll up. Sure. So I think that case is distinguishable. Of course, on the face, that case is dealing with competency. This is a Batson hearing. And I think just the fundamental issue of competency is going to be different than jury voir dire, which we have a record of that all parties were present and can, again, argue about. But again, I would just point to the fact that in Hobbs, we have a case from the North Carolina Supreme Court that directly addressed that, and they did not hold that those same concerns that are present in a competency hearing are present in a Batson case. It's still, I mean, you're talking in 2020, these cases aren't in direct conflict, and we have Hobbs, which is directly on point in this case, and that has held, and I'm sorry if I'm repeating myself, that the trial court can do this, and the Supreme Court sent it back down to the trial court to do this.
But in Hobbs, was there any of this analysis of what the proper remedy should be? Or did they jump straight to this is the appropriate remedy without a discussion of we're going to make a determination or we think the trial court can still make a determination? This language from sides to me suggests the same problem that we're discussing here, a trial court's memory of a tiny event 5 years ago. And suggests to me in a more recent holding that 3 years was too long, and now we're looking at least 5 here. That seems somewhat problematic to me if it wasn't directly addressed and rejected in Hobbs.
Well, by directly addressed, I don't believe it was briefed and the issue was disputed by the parties, because you kind of have Hobbs being one of the first cases kind of delving into what's required of the trial court's explanation of its Batson determination. So that wasn't directly briefed. So by that, I would say it's not directly addressed, but that doesn't mean it wasn't directly addressed, because it was. The Supreme Court found an error and they applied this remedy. So therefore, they're determining the appropriate remedy by the fact that they're doing it. And that doesn't make it, the fact that it wasn't disputed by the parties and that the Supreme Court didn't have to solve a dispute doesn't make that any less binding on this court. Because if it's the same error, then the same remedy in Hobbs must apply. And this court, again, has held that. If you look at Alexander, you look at State v. Hood, you look at these other cases by this court, and that's how this court has interpreted it. It found that it was bound by Hobbs when this type of error occurs. So the fact that the Supreme Court...
Judge Murphy, could you go back? You shared that screen.
Sure thing.
Could you
Yep,
share
sir.
the first page of that opinion, please?
Yep. Let's go. Let me slide up there real quick so I don't pull too much up. Sorry. This is one giant PDF, so give me just a second, and we'll give the state a little more time at the end here.
Yeah, I'm sorry, Mr. Saunders.
That's perfectly okay.
Oh, this should work. Judge Earwood. Let me see here. Is that sharing? Can you see it there, Judge Earwood?
Yes, okay, I see I see what I need to see from it. Thanks.
Thank you. Thank you, Mr. Sanders. And we'll give you an extra minute and a half if you need it there.
Thank you. I appreciate that. So again, just to briefly recap what we've been discussing, the defendant hasn't in any meaningful way distinguished Hobbs or Alexander in these cases, which have directly dealt with this issue of what is required of a trial court's explanation of its Batson determination. And in turning to this case, the state is unable to meaningfully distinguish Hobbs either. So here, the defendant argued to the trial court that Corey M's failure to answer questions on the questionnaire and his comments about the death penalty were consistent with white jurors whom the state passed. The trial court acknowledged this argument, but it did not explain how it considered that argument at Batson's third step. And of course, Judge Poovey, as this court noted, I think rightly in a footnote in Alexander, that the trial courts now, or the cases that are on appeal right now with this issue, most likely did not have the benefit of Hobbs. And in this case, the judge did not have the benefit of Hobbs when he made the ruling. Nevertheless, this court has held that Hobbs is still applicable to pending appellate cases. And this case on appeal, of course, Hobbs applies to it. And the state, given the trial court's consideration or the failure to adequately explain the consideration of the comparative juror analysis, that's the same error in Hobbs, and therefore the same remedy is required in this case, which is remand to the trial court to give it, as the initial enforcer of Batson, the first chance to make these findings of fact and explain why it did not find these comparative juror analysis credible. In this case.
Turning back to the mandate in Hobbs, the majority opinion sort of concludes the trial court is instructed to conduct a Batson hearing consistent with this opinion, to make findings of fact and conclusions of law, and to certify its order to this court within 60 days of the filing date of this opinion, or within such time as the current state of emergency allows. More for my own, I guess, edification, but does the state have a position on what it means for the trial court to certify its order to the Supreme Court within 60 days? Is that more of a function of ensuring the trial court actually conducts this hearing and enters an order, or is that sort of a certification back to the Supreme Court to then conduct a review of the trial court's order? I'm just trying to figure that out. It's interesting language in one of our appellate opinions.
It is interesting, and I don't know that you've seen it in a lot of other cases, but I don't believe there's any. I'm not sure. I'm not sure why that was done, but I don't think it changes anything. So, for example, the Supreme Court in Hobbs found that what the trial court had done was insufficient, and so it gave the trial court a chance to explain its ruling through findings of fact and conclusions of law from a Batson hearing, and then certify it again. The meaning of whether it needs to be certified, I'm not sure, but what actually happened in Hobbs is the trial court did certify its findings back to the Supreme Court, and then I believe it's still pending there. So just procedurally, I think that's what happened in that case. And again, so I think that's wise that the Supreme Court says your ruling, we can't tell from the ruling how you considered this. So have a Batson hearing, make the findings of fact, make the conclusions of law, and consider it, and then we'll apply our usual appellate review of that, determine whether that ruling was clearly erroneous, if that answers your question.
Yes, thank you.
And very briefly, so the defendant has claimed in his supplemental reply brief that the state does not contest the merits of his Batson argument. And he has said here today that the state is trying to kick the can down the road. That's simply not true. The state has maintained on direct review that the prosecutor did not improperly strike Corey M., that the strike of Corey M. was not motivated by a racial discriminatory purpose. It has maintained that throughout the appellate review process, and it has done so now. However, the state is under an obligation to concede to this court when we have a decision by the Supreme Court that is directly applicable to this case, and a certain error is to be found and a certain remedy is to be employed. But that concession that this must happen under our current state of our law is not in any way conceding the merits of the claim. And as the state has discussed in its opening brief, defendants' arguments for why the state's race-neutral explanations were pretext fail. Just very briefly, if you look to his comparative juror analysis, what he is attempting to do is find a single similarity between Corey M. and any of the number of other prospective jurors who were examined in this case and make them substantially similar, but that's just not the case. And our United States Supreme Court, our courts have held that jurors aren't cookie cutters. There aren't going to be any identical jurors in a voir dire. but there still is the requirement of substantial similarity in order to raise an inference of discrimination, and he just hasn't shown that here. He hasn't pointed to a juror. He takes characteristics such as they were single, they were unemployed, but he has not pointed to a juror that is substantially similar to Corey M. Corey M., were there other jurors who left questions blank on the questionnaire? Sure. There were jurors who left 1 or 2 questions blank, but that's undermining the amount of questions that Mr. M did not answer. As the trial court found, he failed to answer a significant number of questions. 26 through 34, 36, 40 through 50, 53, 55, 56B, 57 through 60. No other juror failed to answer that many questions. And that left the state with no starting point. Not only does it show that that juror M could not be bothered to answer these questions, but it left the state with no starting point on his views of the death penalty. So just for example, with that characteristic that the defendant attempts to liken to other jurors, it fails. The disparate questioning, the defendant claims that the state disparately questioned juror M, I think with respect to, I believe he just stated during his argument with respect to the death penalty. But again, that goes back. Corey M did not leave the prosecutor with any starting point. So more questions were necessary. And I don't think if you look to the voir dire, there's any disparate questioning. And he's mentioned intense questioning, but the question with respect to the "we hope we got it right" statement was just whether the nature of a triple homicide caused him any concern. That's not an intense question. That's not intense questioning. And with respect to the press release, for example, the state merely, without offering any evidence as to how that press release came about, the press release simply stated the racial makeup of the jury. That does not in any way indicate an intent to strike Black jurors or to strike jurors on the basis of race. The acknowledgement of Batson does not indicate any kind of intent to discriminate. At that point, when the press release had been released, the defendant had objected on the grounds of Batson. So it's not, I don't think this court can take any kind of inference of discrimination just based on the state after a Batson challenge simply acknowledging the racial makeup of the jury. I mean, each juror questionnaire asked the jurors their race. And he also points to Charlene S. Defendant does not press his Batson objection to Charlene S. on appeal. Rather, he tries to sneak it into Corey M.'s challenge that he raises on appeal. But if you look to Charlene S., it's very clear why the state struck her. She had a lifelong held view of the death penalty. It changed with a matter of minutes. She had the most criminal dispositions of anyone that was examined in the 2,000 plus pages of jury voir dire, I believe 15 dispositions. Her son had been prosecuted by one of the prosecutors in this case. So if you actually get in and look at why these jurors were struck, it shows that the state never intended to, or the state did not strike any juror on the basis of race. But again, this court, the issue before this court on remand is how Hobbs impacts this court's previous decision. And as we discussed here, the state concedes that the same error occurred here and that the trial court did not adequately explain how it conducted this comparative juror analysis, and therefore the same remedy must be applied. This case must be, the appropriate remedy in this case is to remand to the trial court to have a Batson hearing to make the appropriate findings of fact on its determination. And the state would submit that that is the appropriate remedy. Defendant has not shown in any way that he's entitled to a new trial. Thank you.
Mr. Sanders, would you agree with the defendant that the record reflects a 100% strike rate of African-American males?
Of African-American males, yes, but I would like to qualify that with, at the time of Corey M's strike, 3 out of the 4 African-Americans had been struck. And again, we can discuss why those jurors were struck. If you take a closer look, the reasons become evident and they are race neutral. And then by the time jury voir dire finished, I believe the state exercised 3 strikes out of 6 African-Americans by the time jury selection was over.
Thank you. Judge Airwood, Judge Hampson, any other questions? Okay, Mr. DeSimone?
Thank you. May it please the court. You know, purposeful discrimination against Black jurors is such a hard thing for anyone to admit that no appellate court in North Carolina has ever admitted that it has happened. Meanwhile, two appellate courts in North Carolina have upheld findings of purposeful discrimination against white jurors. That record and disparity defies reality and common sense, and it has to stop. The state somehow, the state somehow wants to cabin Hobbes to merely discussing comparative juror analysis. That's an absolute misreading of Hobbes. Hobbes also said that the trial court and the Court of Appeals both erred by failing to consider all of the circumstances that the defense said demonstrated discrimination. Here, that's disparate questioning, that's statistics, that's susceptibility of this case to discrimination. That's the lack of findings on the demeanor reasons. That's pretextual reasons for striking Charlene S. And on that point, if you look at Snyder versus Louisiana, the United States Supreme Court said, this is 2008, that in reviewing a Batson claim, courts must look at all the circumstances bearing on racial animosity. And the court said, quote, here, as just one example, if there were persisting doubts as to the outcome, a court would be required to consider the strike of Ms. Scott for the bearing it might have upon the strike of Mr. Brooks, end quote. Mr. Brooks was the only one at issue. If Hobbes required a remand to the trial court, the Supreme Court would have remanded this case to the trial court. Instead, the Supreme Court remanded this case to this court. That has to mean something. Ferreting out discrimination in this day and age is not glamorous, it's tedious. I only ask that you read Corey M's voir dire and then address each of our arguments in our principal briefs and our supplemental briefs. Even though there is no smoking gun, each one of the pieces of this puzzle point to the conclusion that the state discriminated against Black juror Corey M. If you were to remand, I hope that you will not tie the trial court's hands. The trial court should have to consider all of the circumstances, not just the comparative juror analysis. But we ask that you reverse Mr. Hewitt's convictions without remand for a new Batson hearing so that we can save those scarce judicial resources for a new trial. And that's all I have, and I appreciate your time.
And Mr. Destimone, I know I've asked some questions about the African-American male, and I just want to make sure I'm clear on all the arguments made below. There was never any argument regarding JEB versus Alabama and a mix of that in Batson, correct? We're dealing straight with racial discrimination and no sex discrimination, at least what was raised below.
I believe that's correct, Your Honor.
Thank you.
Thank you.
Sorry. Judge Airwood or Judge Hampson, any more questions? Well, I want to thank both parties for your arguments. And if there's nothing else, Mr. Destimone, you have a little more time, but if there's not anything else, we'll go ahead and close out today. And Mr. Soar, if you'd like to close us out.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you. Thank you, everybody.